You have seen the quotation yourself, and the charge is based on Section 94(1) of the Penal Code. What is called an offensive conduct that is conducive to a breach of the peace. Your Honor, when you look at the ingredients of the offense that is charged with 94 Article 1, the particulars provided don't disclose any of the ingredients even on the face of it, assuming we have witnesses and assuming that we'll be able to do what we call legal surgery, where you have to look at somebody's statement, because I think we are operating for the basis that our client is entitled to exercise her right under Article 33 of the Constitution, the freedom of expression. She's an additional member of Parliament whose right and freedom to expression include much more than her personal rights. She has constituents to present and to speak on their behalf freely without any limitation, as she makes representation on their behalf at both the National Parliament and any public fora where her duty calls. I've looked, when you look at the ingredients, again, there is nothing insulting on the face of this. There is nothing abusive. And with tremendous respect to the office of the Rana DPP, this is the kind of offense that used to be charged, that usually is used to charge a drunken man, the drunken man in the market center, so that we are talking. This is the kind of charge. This is not the kind of charge to bring a member of an elected member of Parliament who is serving her third term in Parliament to court. Thank you, and it's completely on the face of it unconstitutional. But my land, friend, Mr. Jiru, day off, Father, Deepa.
Thank you, Honor. I'll also briefly address you on the legal basis of our application, then I invite my learned friends to further defend the arguments. Yes.
Before we proceed, maybe just for order, how many view, because I can see your battery.
Yes, sir.
How many of you would be?
Thank you, Honor. Although I'm sure would want to make
after Jiru.
And so after Jiru, 2 others.
Yeah, I don't think we have any power to decide for them. Maybe the court could just indicate how much time all the 3 have for order. Instead of telling them how many could speak, we could agree on how. The 3 is okay, yes.
So let them exhaust whatever they have.
Just stick to the point, Your Honor. I'm sure we are going to do business, propose this.
You know, I begin to address you by invoking your jurisdiction. And I do so because with the of the Magistrates Court Act, but let me begin by Section 3, which lays down the guiding principle. In exercise of its judicial authority, a magistrate was specified under Article 10 and Article 159, Clause 2, and Article 232 of the Constitution. That's where you draw your jurisdiction from. And then as you exercise this jurisdiction, when adjudicating of our disputes such as this one, what is the court looking at? And Section 4 says the objective of this says, Your Honor, that subject to Article 165, it is so square borders between a denial, a violation or infringement of a right, a threat to a right, or fundamental freedoms. We address you on the basis that the section under which this charge sheet has been premised, that is section 94, subsection 1, was enacted in 1930, with the commencement date being the 1st of August 1930. It follows therefore, Your Honor, that with the enactment of the new constitution, the old EPP who has brought us here this morning ought to have been alive to the provision of section 7 to the 6th schedule to the Constitution. Section 7 to the 6th schedule, Your Honor, to the Constitution provides that all laws that were in effect before the effective date shall be read with the necessary modification, adaptation, alterations, so as to bring it into conformity with the provision of the Constitution. And while I am not inviting you to look at the constitutionality of that section, I am inviting you to look at whether or not the application of that section falls within the provision of section 8 of the Magistrates Court Act. I want to make it clear so that my learned friends on the other side may understand that I'm not invoking your jurisdiction to determine the constitutionality. I'm invoking your jurisdiction to determine the applicability of that provision. Therefore, in that sense, Your Honor, section 94, subsection 1 must be brought within the ambit of section 7 to the 6th schedule. And the reason why the drafters of the Constitution made a proviso to save the existing laws before the effective date was to make sure that, Your Honor, that granted the circumstances that Parliament is not able to address all laws supposed to bring it to conformity, that the application of such a section may not result into violation of a provision under the Constitution. That is the reason why we have the clause saving the existing laws before the effective dates and hence the enactment of Section 7. Having said that, Your Honor, Section 3 tells you that you must address yourself to Article 10 of the Constitution. And what are you addressing yourself to Article 10? Article 10, subsection, clause 1, provides that Article 10 binds all state organs or even persons whenever any of them is either implementing the law, legislating the law, or formulating a policy. In this case, Your Honor, you are implementing the law. And therefore you are bound by the provisions of Article 10, which lays down the national values and principles of governance. Among those values, Your Honor, is a value of human rights. That human rights binds you. And that is why Section 8 of the Magistrates Court Act, in cognizance of the fact that you are bound by Article 10, has deliberately given you that jurisdiction. Because it is not possible, therefore, for the Constitution to say that Article 10 binds you holistically without any possibility of waiver, and then you are told that you cannot determine a threat, you cannot determine a denial, you cannot determine a violation. Having said that, Your Honor, Article 10 also invites you to look at the rule of law. And also the question of social justice and the principle of equality and equity. That is therefore to say, Your Honor, and I want to associate myself with the submissions made by senior counsel, is there equality, equal application of the law granted the circumstances and the submission that he has made, because I consider them to be legal arguments. Number 2, Your Honor, the application of Article 10 invites you to look at the question of discrimination and Article 27. Because Article 27 falls within Article 10 where you are mandated or commanded by the Constitution to observe human rights. And therefore to say that, Your Honor, when you retire to make our application to the objection of taking plea, this plea does not conform to the dictates of the new Constitution. That is one ground of the objection. That it is not possible for you to ask Honorable Jane Kihara to make a plea that will be unconstitutional for failure to conform to the dictates of Section 7. That's one limb of our argument. The other limb of our argument is that the same does not disclose an offense. Those are 2 grounds. That if she was to make or she was to plead to this offense, one, she does not even understand what offense is actually facing her. Because even if we were to make an assumption for purpose of argument that Section 94 subsection 1 that it was in conformity with the Constitution, is it just the proviso that the Jane Kihara, Honorable, offensive conduct offensive conduct conducive to breach of peace? This proviso of the law must be backed by particulars that speaks to that offense. We therefore submit that the particulars pleaded herein do not speak to the purported or to the alleged offense. These particulars falls within the provisions of Article 33 of the Constitution, the freedom of expression. To admit this charge, therefore, Your Honor, this court would be rising up to the occasion of limiting her rights. And the limitation of these rights, Your Honor, under Article 24, the court has created a test that it must be justifiable for you to limit It must be justifiable in a free, open, democratic, and civilized society. If that then would be the test and granted her status of members of parliament, would the taking of this plea not amount to the limitation of that particular right? And would that right be a justifiable one in a democratic society? A free society such as this one? A civilized society such as this one? That was not the intention of the legislation. That was not the intention of the enactment of the 2010 Constitution. And then even if she were to plead, Your Honor, even if she was to plead, that she made these remarks, Your Honor, would this conform to the provision of Article 50, Clause 2, Paragraph 4? And that's the doctrine I love speaking about, the doctrine of nurum crimen sine lege, that you shall not be charged of an offense if the offense itself was not known in law. And the argument that the offense is not in law is due to the fact of the jurisprudence that has emerged following the enactment of the new constitution vis-a-vis Section 7 of the 6th schedule. That had it been to be brought to the conformity to that provision, this offense would not be existing in our books of law. If we had a proactive parliament, and not a parliament like the one that we currently have, this perhaps would have ceased being good law in our books. But granted the circumstances that parliament itself has not amended this provision, that parliament is too lazy to bring it into conformity with the provisions of Section 7, are we left helpless? Is it therefore that the DPP has the liberty to charge any other person just because parliament has become negligent? Parliament has refused to legislate? You are called upon by Section 8 to rise up to the occasion in the event there is ineptness on one part of state organs. And besides that, I may invite my learned friend, Mr. Kihara. Article 10 places you on the same pedestal with the parliament. Because this court and parliament is bound by that provision. So where there is ineptness and negligence on the part of parliament, the court of law can rise up. In any case, the application of Section 7 vis-a-vis Section 8 of Section 7 to the 6th schedule vis-a-vis Section 8 of the Magistrates Court Act can only be applied by this court, not parliament. So we invite you, Your Honor, to find that there is no offense that has been disclosed by this particular charge sheet. The same is meant to achieve ulterior motives other than that which is contemplated to protect public interest. It is meant to preserve personal egos. It is meant to preserve at a certain equilibrium for which you do not understand personal emotions. Unfortunately, this is a court of law. If anyone feels injured by these particular statements, the recourse is not before you. The recourse is not to criminalize utterances that are constitutionally protected. When you retire, you look at Article 19, 20, 21, and 27 of the Constitution. I invite my life friends.
Sorry, especially those provisions, the last those articles?
Yes, Article 10, Article 19, Article 20, 21, and 27. And finally, Article 33. But also, look at Section 89 of the CPC, when a court can decline to admit a charge. Allow me just to read it as I invite Mr. Kihara. That is Article 90, Section 98, 89, subsection 4. The magistrate, upon receiving a complaint or where an accused person who has been arrested without a warrant is brought before him, shall, subject to the provisions of subsection 5, draw up or cause to be drawn up, and shall sign a formal charge containing a statement of the offence, with which the accused is charged unless the charge is signed and presented by the police or the ODPP. That has been done. When it is brought before you, Your Honor, then you are supposed to invoke subsection 5, where the magistrate is of the opinion that a complaint or a formal charge made or presented under this section does not disclose an offence. The magistrate shall make an order refusing to admit the complaint or formal charge, and shall record these reasons for the order. I invite Mr. Kihara.
And Your Honor, that is a perfect starting point for me. And I'll be giving you reasons why we should not admit this charge. This charge is drawn, and it is alleged that the person before you has done something contrary to section 84, subsection 1 of the Penal Code. And Your Honor, that is the section which I've opened. That section, and if I may just read the words that are in the charge sheet, that Jane Jerry Wajiro Kihara, on 8th day of July 2025, at Nairobi City within Nairobi County, being in a public gathering, uttered the words to read. Now the words are there, the paragraph is there. It concludes, with intent to provoke breach of peace. So, I submit that that charge, as drafted, does not disclose any offense under section 94, subsection 1 of the Penal Code. These are the reasons you know. That section reads, a person who in a public place or a public gathering uses threatening, that's one, abusing, that's the second one, or insulting words or behavior. So, the operative words here are, those words must either be threatening, there is no suggestion that she used any threatening words, abusive, it is not alleged she used abusive words, or insulting words or behavior, it is not suggested that she used any insulting words. And then that is when an offense is constituted. So the charge that is before you does not have threatening, abusive, or insulting words or even behavior that would go on and cause breach of peace and all that. So basically, the offense that is before you is hollow. The other part of the section is just saying how minor that offense is just a fine of 5,000 shillings.
Can you address the other element?
Yes, I'm coming to that. I just caught my eye in the fine, which is 5,000 shillings. So then, with threatening, abusive, or insulting words or behavior, is no suggestion that has taken place with the intent, one, to provoke breach of peace. That is the one that has been taken. So that for you to have an offense where the intent is to provoke breach of peace, those words or that conduct must fall within the 3 parameters, or any of the 3 parameters that I mentioned. What is before you does not fall under any of them. Under subsection 2, the Act then defines what is a public gathering. And what you will find is that one situation where there is a gathering is when there is any meeting. So basically, when a judge reads a public gathering, a prosecutor must take the charge to what kind of a gathering. Is it a meeting? Under paragraph 8. Gathering or concourse of 10 or more persons in any public space. So you're not being told, were they 2 people? Were they 1? Were they 3? Because the minimum number is 10 or more. And it must also be in a public place. This church does not say the public place or any place. We are just being told in Nairobi. All of us in Nairobi. Yeah, even here is in Nairobi. So, which is the public place? So, that way, the offense is not disclosed. Paragraph B. Any meeting or gathering which the public or any section of the public of more than 50 persons are permitted to attend or do attend, whether on payment or otherwise. There is no suggestion, it's not been indicated whether there were 50 people, whether these people paid to be there, they didn't pay to be there. So what is Honorable Kihara supposed to defend? These particulars are not in the church. And finally, the other situation is the paragraph C. Any procession in, to, or from a public place. Any procession moving in or out of a public place. We are not told that these words were uttered in the prosecutions. When a charge is brought before you, under section 94, under section 134 of the CPC, one thing that should stand out is the following: that every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving a reasonable information as to the nature of the offense charged. The information that is contained in this charge, Your Honor, is insufficient under subsection 1. It is insufficient under subsection 2 of section 94 of the Penal Code. Would it be right then if I shift to that point? You know, when a charge, and the section which I have just referred to, that is section 134, is indeed the section that implements the provisions of Article 50, sub-Article 2, paragraph B of the Constitution, that provides that every accused person has a right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer it. The charge that is before you does not have sufficient details as defined in the implementing statute. So if she goes ahead and pleads, the judge has brought before you, it will be a violation of Article 50. Article 2, paragraph. And important to mention, Your Honor, that under Article 25 of the Constitution, and for emphasis, I want to read what it says. That despite any other provision in this Constitution, the following rights and freedoms shall not be limited. These are rights which cannot be limited. And one of such is the right to fair trial. That is paragraph C of Article 25. The right to fair trial is the one that I had talked about under Article 50. So you are then placed in a position where you have a charge that is in contravention of Article 50, and you're being asked to allow a person to plead to those charges. Your Honor, decline that invitation. And Your Honor, I do not want to talk much because before we came here, we were before you again in another matter with the same prosecution team and Mr. Mageto for Honorable Bongori. And yesterday we slept very late because we were at the DCA headquarters to deal with an issue of Honorable Mekuchi. And now we went to the other day, then yesterday we were dealing with Jim. And no. So that Your Honor, I do not want to tire you because you're also very stretched. But the context of that is that there is a pattern, and this court should rise to the occasion and see what is happening and uphold the Constitution. And that will be done. And I invite my other friend, our chairman, Mr. Mbogo Wanjohi, to make something.
No, that is not the introduction it is to our chairman. This is our chairman of Game Award, which is an organization of about 6,000 lawyers. So you cannot just give that introduction, please.
Thank you. Well, it's another thing to
we have an association which has about 8,000 lawyers practicing in Kenya, others in Kenya. It's called the Game Award Association. Very many lawyers.
What he's not telling you is that he has now incorporated our cousins from Mount Kenya South.
Thank you.
Thanks for that introduction. Your Honor, again, my name is Wambo Wanjohi, and allow me to concur with what my senior, Mr. C.M. Kihara, said, and what the state is doing. The state is using fire extinguishers to blow out a candle. Section 94 was meant for brawls in bars and fistfights in funerals. That is the purpose of Section 94. the penal code. But, Your Honor, let me go into why these charges before you are effective. Number one, Your Honor, there is no clear offensive conduct that has been identified. Section 84 says the charge itself is offensive conduct conducive to breach of peace, contrary to Section 94 of the Penal Code. Under the charge does not specify what part of the charge was actually offensive. And a simple reading of these particulars, I will just cherry pick some. I would say I want to talk about Naivasha because I know the goons were transported in NYS bus. How is that offensive? I want to tell the president, this is not about the young people who you went around promising heaven and what you are digging deep so that they go under. It will not happen. How is that offensive? Number two, if the president has been mentioned in this particular charge sheet, he is not among the witnesses. You see the complainants? Second, Your Honor, the use of vague words like offensive conduct without defining how and why it was offensive makes the charge overly broad and ambiguous. Secondly, Your Honor, no particulars of breach or threat to peace has been disclosed. The charge alleges intent to provoke breach of peace, but fails to state the following things. What disturbance followed, if any? Who was provoked? What specific act of violence or disorder was caused or threatened? There is no breach of peace in these particulars that accompany this charge. Third, Your Honor, we submit that speech alone is not automatically conduct. Section 94 is meant to criminalize conduct. It is clear. Offensive conduct conducive to breaches of peace. It does not criminalize opinions and political expressions. If the charge is based solely on speech, then the prosecution must show that the speech had a clear and present danger of causing peace. This threshold, Your Honor, has not been met. Fourth, Your Honor, we submit that no mens rea is alleged, save for with intent to provoke breach of peace. To which we say the charge does not state intent or even suggest that Jane knew her words would provoke unrest. What she was doing was expressing her political opinions, guaranteed under Article 33. Now, Your Honor, fifth, we want to go to the issues of Article 50, 2B, and K of the Constitution, whereby the accused has a right to be informed of the charge in sufficient detail, presumed innocent, and not to be convicted for conduct that is not clearly defined as an offense in law. Your Honor, this charge is too vague and imprecise to meet these standards. Sixth, Your Honor, there is no link between the words and the alleged offense. Even if this speech was quoted in full, it shows no incitement to violence. Actually, she's even giving her condolences. As I condole with the bereaved, quote, and I also empathize with those whose properties were destroyed. So this speech does not show any incitement to violence or encouragement of disorderly conduct. Condolences, criticism of police, political frustration, how is that a criminal act, Your Honor? And if that was the case, I believe half of Parliament would be in committee. Seventh, Your Honor, as I conclude, this this is a gross misapplication of the Penal Code. As I indicated, this provision is for brawls in bars and fistfights in funerals, and should not be used as a tool to criminalize free speech, however loud or uncomfortable it is. Finally, Your Honor, submit that even if all these alleged facts were true, they will still not amount to breach of peace under Section 94. Which makes the charge fatally flawed and ripe for striking out at the earliest instance. This will submit.
You want to cede the floor for 1 minute to Councillor Iregi, and then
Your last one.
yeah, last one. Then I probably just wrap it up in a minute.
Even though the agreement was that it was 2, I know this is mathematics, and I know lawyers. It was 2 after council, and that is the third. So but we have no objection.
Thank you.
That's mathematics.
Thank you.
Mr. Waimini.
Yes, sir.
So for 1 minute here.
Yes, 1 minute. I wish to address you on an issue that has not been addressed by my colleagues at senior, as to what should happen in the intervening period when you retire to render a decision on the validity of the charge before you. Your Honor, the charge, as rightly put, is one under Section 94(1), a misdemeanor. And in light of the provisions of Article number 49(2), a violation is ensuing at the moment, in that our client is in custody. Article 49(2), the rights of an arrested person, provide that a person shall not be remanded in custody for an offense if the offense is punishable by a fine only, or by imprisonment for not more than 6 months. The one before court is one that qualifies under 49(2). As such, in the intervening period, it will ask for release of the arrested honorable man on her personal cognizance.
Your Honor, Honorable Jane was apprehended in Naivasha in her constituency. And was escorted by a convoy of 30 officers, approximately, because she agreed us. Two Land Cruisers, Your Honor, and the famous Subarus. Only to be presented before you this morning, the charge is a misdemeanor.
When was she arrested?
I believe it's on Saturday? Yesterday. Yesterday, Your Honor, lunch hour. When I spoke to her, she was at DCI headquarters last night. As senior counsel, I thought, from what she told me, we did not have to use public resources to come in this morning for misdemeanor. So I tried to talk to the deputy DCI, who told me I was going to look into that matter. And if they had properly applied their minds, she should not be before you, Your Honor. That's our submission. Finally, Your Honor, I want to refer you to the provisions of Article 2 of our Constitution. Which of course declares that this Constitution is the supreme law of the Republic and binds all persons and all state organs at both levels of government. Sub-Article 4, Your Honor, of section of Article 2, any law, including customary law, that is inconsistent with this Constitution is void to the extent of the inconsistency. And any act or mission in contravention of this Constitution is invalid. Your Honor, my submission is that alleged breach of Article Section 94(1) of the Penal Code is unconstitutional. Because in violation of the very Constitution itself. And Your Honor, as Kenyans we should be very proud that we imported under Article 20, 19 and 20 of the Constitution the Bill of Rights. Therefore it behooves all of us, Your Honor, our courts of justice taking leadership to ensure strict adherence with Constitution 2010 and its valuable provisions, which actually is a constitution that gives freedom of expression. We've been addressed on that. Therefore, our plea, in conclusion, Your Honor, is that this harassment through you should stop. I found you recently, I do not know whether it was before you, when we had the privilege to appear together with Chief Justice Emeritus in the case of Rosenjeri.
No, it was a different one.
You look like...
He's not my brother.
Yeah, you look like... Your Honor, Rosenjeri is a very good case to refer to at this time. When the magistrate, your brother magistrate, simply let her off. When he retired to consider submission, Rosenjeri is a free citizen. She did not have to plead to a ridiculous charge. We ask Your Honor that Honorable Jane Kihara, whom I know as a mother and a senior leader, she had serving her third term in Parliament, should not be before you for a misdemeanor. So we urge that when you retire to consider application, that you will let her off. In any event, you had the maximum sentence for such an offense, a fine of 5,000 shillings. A real misdemeanor. So we urge that you order immediate release of Honorable Jane Kihara, and we ask our colleagues in the political space to just adhere to the Constitution. That's all we are saying. I thank you all.
All right, thank you, sir. That's all you have.
Thank you, Your Honor, once again. It must be afternoon already. Good afternoon.
Good afternoon.
we oppose the application for deferment and or rejection of these charges. And while we respect our colleagues on the other side, and we must commend them for a very good arguments today, especially my learned colleague, Mr. Njero, who I think must have preempted my arguments under Section 8. We've done this within several so I could see what he was doing. But Your Honor, I understand the application for rejection and or deferment of these charges to be founded either on Section 89, 4 or 5 by Mr. Ndegwa, or Section 134 by Mr. The name is difficult. Not 89, 4 or 5, I think we could easily drop 89, 4, which deals with the drafting of charge. But 89, 5 about rejection of charges, or 134 as to, the propriety and contents of a charge sheet. And I thank Mr. Watuta for bringing 134 up because Learned Senior Counsel has referred to a case before your brother, in which a charge was rejected on the basis of Section 89.5 on the same arguments, but which case from the onset we could say you're not bound by because it's a court of concurrent jurisdiction, it's not a superior court decision, and two, a decision which may have been issued in error, and I will tell the court why. The arguments other than being based on Sections 89 and Section 134 of the Criminal Procedure Code also is founded on a conflation of the criminal law vis-a-vis constitutional law of Kenya, and which needs some unpacking, a little bit of unpacking. And I'll say again that Mr. Ndegwa has done so well in his arguments on the constitutional perspective, which then but for all of us, any court can only do as much as they are provided to do in terms of jurisdiction. Without jurisdiction, a court downs its tools, in which case you will down your blue pen if you are asked to do something outside your jurisdiction. As correctly noted by Mr. Ndegwa, the jurisdiction of the Magistrates Court to hear and determine criminal cases is provided for under Section 8, the jurisdiction of this court to hear and determine questions of alleged violation of the Constitution or of Bill of Rights is provided for under Section 8. Interestingly, I was listening so keenly, my learned colleague goes to Section 3, Section 4, then he gets to 8 and tells you Section 8.1. I want to read 8.1, which he referred to, if you permit me. I can go to that as they look for it for me because it seems it's not in my bundle. My colleague is assisting me with it. But in a sense, what it says from the reading as we wait for the actual text is that the magistracy have the power to interpret and apply the Constitution. Yes, correct. Thank you, sir. 8.1 claims relating to violation of human rights. That subject to Article 165(3)(b), which I'll come to shortly, of the Constitution, and pecuniary limitations set out in Section 7.1, a magistrate's court shall have jurisdiction to hear and determine applications. Hear and determine applications for redress of a denial, violation, or infringement of, or threat to right or fundamental freedom in the Bill of Rights. It does excellently well by bringing that out. But it leaves 8.2. Let's go to 8.2. The applications contemplated in subsection 1 shall only relate to the rights guaranteed in Article 25A and B of the Constitution. He deliberately ignored it because we've had this discussion. So that if there were allegations, if the arguments are based on alleged violations of rights of the Bill of Rights or any provision of the Constitution, if they went outside Article 25A and B, this court must drop its pen in respect of all the other provisions of the Constitution. And that will include Article 10, Article 19, Article 20, Article 21 and Article 27 and 33. But I'll address 33 again shortly. Because you do not have jurisdiction to hear allegations of discriminatory charges, if at all, if that's what they are saying, you would love to, but the Constitution says no. Another fundamental and a very beautiful argument that my learned colleague has made today in this element is that Section 94 was enacted on the first, became effective on 1st of August 1930. I must confess I didn't know, but I believe him. It's a good man. But he then gives the response and says there is Section 7 of Schedule 6. And it tells us what it says, that if there was a law existing before this Constitution, then read it with the necessary adoption, alteration, or amendments to bring it into conformity with this Constitution. So that answers the most difficult question he raised. Can we apply a law that was enacted in 1980 today? The answer is yes, and the reason is Section 7 of Schedule 6 of the Constitution. To that extent, Section 94 of the Penal Code, which was enacted in 1980 and which provides for the offense described in the charge sheet, then is still applicable today. And then there's another fundamental argument again in this element. That one, you are at the same pedestal with the Parliament by dint of Article 10, that's correct. But that Parliament has been negligent. And that because of their negligence, don't be negligent, help them out. Interestingly, the suspect is a member of Parliament. It's very interesting. So that the suspect was negligent, leading to charges against her. But that is not by the wayside. Now, Article 2, which Senior Counsel refers to, and I'll refer the court to Article 2, I think sub-Article 2 of Article 2, let me just look at it. And it says, no person may claim or exercise state authority except as authorized under this Constitution. You have no powers to make law. You have no powers to repeal laws. You have no powers to amend laws. That power belongs to Parliament. That Parliament, which is inept and or negligent, in the words of the defense, is the only authority under this Constitution to make, amend, or repeal laws. And related to that, therefore, is that as long as that law has not been repealed, it remains part of the law of Kenya. And if that argument is correct, and I believe it is correct, then the argument about Article 50, sub-Article 2N, which is a very easy one to answer as we go on, that every accused person has a right not to be tried for an offense in respect of an act or omission, N, not to be convicted for an act or omission that at the time it was committed or omitted was not an offense in Kenya. This offense is an offense in Kenya since 1980. So until it is repealed, this court and the Office of the Director of Public Prosecutions has an obligation to enforce the law. There are very many fundamental issues of the Constitution, that's why I've taken some time on it. There is the question about Article 52B, which I'll marry with what I've just said about 52N. I have tried to persuade other benches of the judiciary, and I will try to persuade you today, that there was a deliberate intention to separate Article 49 and Article 50 of the Constitution. This is what I teach my law students at the Kenya School of Law in my guest lectures. That it was deliberate to separate the rights of an arrested person vis-a-vis the rights of an accused person from a commonsensical look of the Constitution. So that when Senior Counsel started giving his opening speech, he says, no, I should not call her accused, let me call her suspect for now. And which I agree with, that you are dealing with a suspect, not an accused person. Then that, if I persuade you, takes you outside Article 50 of the Constitution, which is the rights of an accused person. So that in other words, we're saying the rights under Article 50 are triggered upon the taking of plea. That argument may not be correct, but we are trying to persuade you that it is correct. And I hope we are right. Because it is this court that makes that determination. So then, Article 52, Article 2B and 2N, we agree with our colleagues on the application of Article 25, that it cannot be limited by all means. But having spoken about there is the possibility of limitation of rights outside Article 25 by dint of Article 24 of the Constitution, that it permits the limitation of rights except Article 25 rights. In the democratic society, I believe ours remains an open and democratic society, at least from my end. I hope you will enjoy my submissions like I did his, my first meeting.
Let's give this interview.
So then, that deals with, I think, 4 and Section 4 tells you that you are bound by Article 10 of the Constitution, which is correct. All state and public officers under this Constitution are bound by Article 10 of the Constitution. However, the application, because Council tries to make a distinction between interpretation and application, but whichever distinction it makes, the application of Article 10 still must be within the jurisdictional limits of this court. You cannot just say that because Article 10 binds me, if the High Court is wrong, I can correct the High Court because Article 10 obligates all of us to defend the Constitution. So Article 10 must still be interpreted in line with other provisions of the Constitution and statutory provisions. But now we come back to the charge sheet, having done that constitutional analysis. You know, the reason I mentioned that your brother may have been in error in rejecting the charges under by dint of the provisions of Section 89(5) against Rosenjeri. Of course, there will be a question whether or not the DPP appeals. That will be a different question. But this is why. The Honorable, allow me to read from my phone, Your Honor. I didn't know this would arise, so I didn't bring copies, but I can supply these copies. In a decision by the High Court of Kenya in Milimani, Honorable Grace Ngenyi Masharia, in the case of the Director of Public Prosecutions versus Kuldip, K-U-L-D-I-P, Kuldip Madan and another. This was a miscellaneous criminal application number 809 of 2018, and it is reported in the Kenya Law Reports in 2019. It has very many beautiful provisions which I would have loved to read, but I'll just go to a few of them, all the way from paragraph 28, 29, 30, 31, 32, 33, and 34. But for purposes of brevity of time, allow me to read 33 and 34. This is what the learned lady says, and this got me interested because it clarifies the applicability of Section 89, including 89(5) of the Criminal Procedure Code. And this is what she says. It is my view that the formal charges properly drafted by a police officer or a public prosecutor, I hope my colleagues can get it online and just confirm that I'm reading the correct thing. It is my view that the formal charges properly drafted by a police officer or a public prosecutor, as is currently the procedure in our jurisdiction, should be governed by sections 134 to 137, and that's why I appreciated Mr. Tuta for bringing 134 up of the Criminal Procedure Code. Even if these provisions do not expressly provide for rejection of a charge, that provision does not fetter the court's inherent powers to control its processes from abuse. This is in view of the fact that the courts of superior jurisdiction have settled the jurisprudence that would render a charge sheet effective, which argument can be advanced before a magistrate to persuade the court to reject a charge. Therefore, nothing stops an accused from advancing that a charge sheet is effective within the scope of the settled law, after which a court may find accordingly. A magistrate, if persuaded to reject a charge, should also address himself to whether the charge satisfies section 134 of the Criminal Procedure Code. That ought to apply to each charge in the incident application. But this is the most important 34. Having made my observation on the application of section 89 of the Criminal Procedure Code, I feel that courts should not continue to apply this piece of legislation to reject charges. The provision no longer speaks to the current procedure used of bringing charges to court. It no longer retains the meaning it had when Parliament legislated it. In other words, the arguments under 89 collapse because the decision of Honorable Grace Ngenyi Macharia binds this court. So that all the arguments under 89 fall by the wayside. And then that leaves us with section 134 of the Criminal Procedure Code. Council has taken us through section 134, but let's just look at it one more time. Every charge or information, in this case charge, shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged. Insulting. If they admit, unless I'm saying So in constitutional doctrines, we would say that this application is non-justiciable because it is not right. Because for them to know whether or not these elements are met, and whether or not these words are unfit, threatening, abusive, and insulting, we must bring witnesses, and they will have an opportunity to cross-examine these witnesses. So, other than on the basis of common sense, even on the basis of the law, what the defense is asking you to do is not to reject these charges because they do not disclose the particulars. Because the particulars are here in English. They are in bold and they are italicized. What they are saying is they doubt whether or not these particulars prove the offense under Section 94(1). Now, under Article 157(6)(a), and again, this constitution power can only be exercised in terms of the Constitution. The Director of Public Prosecutions has powers to institute criminal proceedings against anyone, including the suspect, for any offense, including Section 94, alleged to have been committed before any court, including this court. So that it is not for the defense to tell us that this offense is fit for bar brawls and drunkards. That's actually funny again, I saw you laugh. It's actually funny. The person who determines whether it is a drunkard should be charged with this offense is constitutionally vested with the Director of Public Prosecution, currently Mr. Renson Ngonga. So if that is correct, if they are unhappy with this offense, they can propose a better offense which fits, the stature of the suspect. But for now, we want to charge the suspect. In fact, Mr. Wakuta wonders charging their client with an offense for 5,000. We are willing to charge her with another one for 1 million, if they recommend. But for now, we are charging her with one where the fine is right. That's actually a constitutional argument. As I conclude, I am going back to Article 24 of the Constitution vis-a-vis Article 33 of the Constitution. The third argument by the defense is that if you allow these charges to stand, then the plea will be unconstitutional. This is the first time I've heard that a plea can be unconstitutional. But in constitutional law, we have had a lot of things. It is admitted by both sides that rights outside Article 25 can be limited in an open and democratic society. It is not denied that Kenya is an open and democratic society. Then Article 33 gives the right to freedom of speech. It is not Article 25, so we can limit it. How do we limit it? Article 33, sub-article 2, if I believe. 33.2 be reminded by my colleagues. Because there is, as I said, been a conflation of the criminal law and constitutional law. So 33.2b, it says, let me just start from 33.1. Every person has the right to freedom of expression, which includes freedom to seek, receive, or impart information or ideas, freedom of artistic creativity, and academic freedom, and freedom of scientific research. Then 33.2 says, the right to freedom of expression does not extend to propaganda for war. B, incitement to violence. C, hate speech. And it goes on. So that the right to Article 33 cannot just be flashed out and say, whatever is said, and in the words from one of the council, even if it is uncomfortable to you. The Constitution says that there will be times when that right will be limited. And that right, therefore, is limited not just by Article 33.2. It is also limited by Section 94.1, which creates the offense. And the honor, for those of us who love constitutional law, Section 94.1 is therefore what we call a normative derivative of Article 33.1 and 2. So that, Your Honor, all this discussion can be made back to Section 134 of the Criminal Procedure Code. That all that is required of the prosecution is to have a statement of the offense. We have that. To have the particulars of the alleged offense, we have the allegations here which we are saying the suspect said. There is no requirement under section 134 that the quality must get to certain level. It should just be sufficient to understand. And they understand. The only disagreement is that it does not disclose threatening, abusive, or the third. If you find for us that in fact we have met the provisions of section 134 of the Criminal Procedure Code, then the defense, because we will meet with them, I'm sure they are experts in this area, must be stopped from this practice of forcing us towards mini trials instead of taking plea. We urge you that the best approach should be that plea should be taken, and then witnesses should be cross-examined. Then the court makes a determination whether or not the elements have been proved at section 210 acquits, or discharges or acquits, and at section 215 acquits. That has, this matter is not right. The application is not right as we speak. In conclusion, Your Honor, if the defense think that there has been an alleged violation of rights of the suspect outside Article 25, this building also quotes the High Court of Kenya in terms of Article 165 of the Constitution. They know the proper pleading and the proper forum. Allow me to finish on a good note. We were not going to oppose bail if number one. And we agree with the arguments of counsel that this offense is a misdemeanor, and I salute you, sir, because that came out towards the end, that because it's a misdemeanor, it would be illegal to hold the suspect pending other motions. We would, however, require that, request the court that you require that there is some personal cognizance or whatever form for her release. We thank you, unless there's a question.
So on the flip side,
yes,
Mr. Whitty, if it's about speculating, they believe to say what they are alluding to is right. I'm sure the DPP has a right to amend.
Yes, that's correct. And that's what 135 says, now that you brought it, Your Honor. That if the court finds that we have not met the test in 134, then we go to 135.
I wanted to say that because I want to give them an opportunity to address that issue.
Yes. That's
so
right.
Thank you.
I'm also blind.
Any other on your end? You are done.
My people say that carry the donkey. I hope I've done them.
I will briefly respond to the issues raised by Kihara, and then I invite the chairman to address it quickly. There is no misconception that, but I want to begin that nilimwacha aongee kimtoke. Your Honor, you have been told that section 94 subsection 1 is what counsel is defining as normative derivative. That's a misconception. In constitutional law, that provision does not qualify to be defined by that doctrine. The simple reading of the word normative means it relates to a norm, a rule, or a thing that should be. So if you were to argue therefore that section 94 subsection 1 is to be constituted or to be construed as a normative derivative vis-a-vis the provision of Article 33, the question therefore posed to the court therefore in determining the norm in section 93 would be, in normal circumstances, how would court regard such a statement by the charge sheet? What norm is arising or accruing from the particulars of that charge? And must that norm conform to the provision of section 7 of the 6th schedule? Again, simple reading of derivative means which can refer to something that is derived or taken from something else.
Do you want it made more punchy for a general?
It's about, let's go to say, section 94, subsection 1. If you were to juxtapose it to the normative derivative doctrine, vis-a-vis the provision of Article 24, cannot then be said to have accrued or arisen from the provision of Article 33. And that is why Council misses the point. Of course, deliberately so, because he does not want to appreciate the fact that Section 7 of the 6th schedule was enacted so that it can assist the court where an amendment has not been initiated by the relevant authority. I concede it's only Parliament that can legislate. Yes, that I concede. But in the absence of a legislation, what is the import of Section 7 of the 6th schedule? And what is the scope of the application of Section 7 of the 6th schedule? If the scope is not such, the scope of application is not such as this one. The reason why Parliament, the reason why the people of Kenya enacted Section 7 of the 6th schedule, they were alive to the fact that not all laws that may suffer amendments or repeals upon the enactment of the new constitution. And therefore they created an avenue for a magistrate or a judge to have the flexibility of dealing with a situation as and when it arises. Of course, my learned friend would want to argue, on the contrary, that it calls you, it limits you and makes you rigid to the interpretation. That is not the expectation. He has addressed you on the question of the repeal. If, even when a repeal has not approved of a section that is not in conformity with the Constitution, the obligation of the court faced with such a challenge is to make sure that that section does not defeat the purpose for which the Constitution was enacted. And then where do you get that purpose? You get that purpose under Article 10. For the benefit of my learned friend, who seldom practices constitutional law, Article 10 says, the national values and principles of governance in this article binds all state organs, state officers, public officers, and all persons whenever any of them applies to the Constitution. That is not what you're inviting me to. Enact, applies or interprets the law. That is what you're inviting me to. This law, Section 19, Section 94, subsection 1. And at this juncture, Your Honor, you might want to seek the aid of the interpretation.
Council should just stick to what came out and the law so that we are not able
He addressed you on the applicability of Article 10, Your Honor, and I have simply dealt with the question of Article 10. I invite you to apply the tool of the golden rule. In 1930, when this section was being enacted, what was most relevant was the mischief rule that Parliament, as at that time, wanted to address. And this case is the Parliament of the United Kingdom. Granted that this country was a protectorate as at then, and Her Majesty government wanted to guard, control, and subjugate the people of Kenya.
Seriously.
Yeah, that's what.
Okay, I'll abandon that, but I know the court has noted. Now that we have the new constitution, so that you may not resort into the absurdity that the DPP is inviting you to, you must apply the tool that enhances the enjoyment of a right other than to limit it. And that you're being invited by Article 19, 20, and 21. To argue that Section 8 of the Magistrate Code limits you, again, would be to miss the point. There is no possibility that the Constitution can give you, under Article 10, which provides, again about these values, and I want to just mention the value of human rights. That when seated there, Your Honor, you are bound by the values of human rights. And where do you get these values from? The Bill of Rights. So are you then supposed to apply the Bill of Rights exclusively? If you're then being invited that the only jurisdiction is under Section 8, subsection 2, then how are those rights contemplated? They are capable of being denied, violated, threatened, or infringed. By the deliberate use of the word threat in the section, threat, violation, denial, or infringement invites you to holistically analyze the entire concept of human rights. It does therefore not limit you under Section 8, subsection 2. Otherwise, how can the Constitution give you and then a legislation take it away from you? Then when interpreting that Section 8, again, you must interpret it in a manner that advances the enjoyment of that right, other than limiting it. Again, that is again on the doctrine of the law, that you expound the law in a manner that facilitates the achievement of that objective. I will again address you on Article 50, Clause 2, Paragraph B. And this, I'll leave it at this and then invite Mr. Kihara, because this article, Your Honor, tells you that when a subject such as honorable member is brought before you, must be informed of the charges with sufficient details to answer. So the DPP does not just have the liberty of crafting anything and anything goes. That as long as you are here, the only obligation is to answer.
Your Honor, this argument was made by counsel when they were making their argument. What we understand, let me finish. Let us just have courtesy. What we understand as a response, just sit and finish it.
So just sit down.
Yeah. You know that they don't have a place to sit.
No, we are pleading that in response, so that we don't agitate, we just issues that have arisen.
Okay, I'll abandon that argument. I'll take that protection. So that, Your Honor, I'll then invite my and try to proceed.
So, Mr. Nero, before you invite,
yes, sir.
Don't you think if you urge me, as you have done, in view of that Section 7 of the 6th section,
yes,
do you think that will be cited for judicial overreach?
No.
It will be a classic case of judicial overreach.
There is no judicial overreach, because if I was to read, and again for the benefit of my learned friend who seldom refers to it.
Sorry, this second time I'm not taking it. I am a master's holder in constitutional law. It's not. I am an advanced master's holder in constitutional law. It's not. So you should not throw those shades. I am extremely intelligent and brilliant and learned. You should not throw the shades.
It's one thing to hold a master's and...
Sorry, yeah, I'm not on trial, Your Honor. I'm asking you to just respect me because I am not... No. Yes, this is the second time counsel is attacking me and I seldom, but I am asking him to respect me because he's my friend.
Okay.
That's not the matter.
Yes, Your Honor.
Mr. Which has demonstrated its credentials.
Yes.
Let's not challenge.
And we are not surprised by those credentials, but surprised by the inability to apply the same.
I am not the kind of person to be intimidated by people like this and that. So this court should just direct him that he respects the court if he doesn't want to respect me. And if he doesn't want me to lose my respect for him today. Because I take my education seriously, having listened from Islam, that I can't allow someone to just make shades. So please, just respect me.
Let's not listen to that. I was actually about to praise the council for their appropriateness and their propriety, but now I think we almost descended.
Yeah.
Let's just maintain our cool and decorum.
Well,
You already wound up. I was just expressing that perspective.
Yes, Your Honor. There is no judicial because the philosophy behind the enactment of Section 7 was in the mind of the drafters of the Constitution that there exist laws and there was need and the necessity to save those laws so that they may not all be considered to be inconsistent with the Constitution by virtue of Article 2 of the Constitution. And that is why, Your Honor, Section 7 says all laws in force immediately before the effective date continues in force and shall be construed with the alteration, adaptation, qualification, and exceptions necessary to bring it into conformity with this Constitution. So this is an invitation to any judicial officer who seeks to adjudicate over a dispute. Additionally, Your Honor, this is also in respect to any other state organ that is invited to apply laws. For example, the procurement laws that were enforced before then, or perhaps the marine laws that were enforced before then, or any other law. So there will be no judicial override, Your Honor, if you are then to apply, because that is a constitutional invitation that you cannot avoid. Most of that.
Thank you, Council. You're the last one, Mr. President.
I think the chairman has 2 sentences.
Your Honor, I don't know whether this would be an interruption of the proceedings.
Mr. Witty has a habit of always rising when I rise. If I stand, I can submit when he's standing. I don't have a problem. But let me make the submission.
Your Honor, I was just going to make a small request. I am not your enemy, sir. I was going to make a request that before they are done, we let them finish. I just want to mention an authority. I'm not arguing. Just bring it to your attention if you allow me to read a paragraph so that as he responds, they also tackle.
No, we are beyond that.
I am allowed to make an application to reopen.
He has already closed his case.
Yes. I'll address that. Let's just finish with that.
Okay, that's fine.
They are responding to what you raised.
He cannot be allowed to be sitting.
I think the court has directed. The court has directed.
Yes.
Yeah, very briefly. There is a suggestion that we are inviting you to a mini trial prior to appeal. In many words, that's how we call it. We are not asking you to evaluate any evidence. We are only asking you to look at the content of the charge sheet in terms of the wording and look at the relevant section of the law that is said to be based and make a judicial determination in accordance with section 18. Subsection 5 Also, section 194. That is all that we are asking for. When prosecution brings a case before you, a charge sheet that is before you and suspect before you, it is in exercise of the ODPP's power under Article 57. We may talk about this. And as I had said earlier, this power must not be abused. Indeed, and Mr. Witty knows this very well, that what sub-article 11 says is that that power of the DPP, in exercising the powers conferred under this article, the DPP shall have regard to the public interest, the interest of the administration of justice, and the need to prevent and avoid abuse of the legal process. A charge sheet is brought before you that is clearly an abuse of the process. Your Honor, that is a charge sheet that you should reject, and the court gives you, the law gives you that power. Lastly, last today, Mr. Kibe Mungai told us in another court setup, that there's a reason why that the new constitution, the bar on this side, the defense, the prosecution, and the bench was made to be advocates. We no longer have police officers on that side, advocates, and then there used to be district magistrates on that side. Those days. Now we have advocates. So that when materials are brought before the courts, the level at which we interrogate them is not the basic level. We should present before the court, and then before the court, and the court applies its mind, its legal mind, to assess a situation so that we prevent and avoid abuse of process. How do I say this? There was a suggestion by the Fred that when a charge sheet is brought before you, your role is to tell the accused person plead guilty or not guilty, and then evidence will come to prove or fail to prove. That is not what the Constitution envisaged. It envisaged a situation whereby all the parties would have some basic meeting of mind as advocates, that indeed this charge sheet, we may fail in evidence, and this one is also in the position to charge guidelines. We may not attain 100%, but it is unreasonable. The charge sheet is in the direction of something that we can prove. So you're being told, yes, there's nothing threatening, there's nothing insulting, there's nothing offensive, but nonetheless, let her take plea. We will move along and see what we will do along the way.
I hope we didn't say that. I hope the record will help us.
Let's move. We'll learn where we find ourselves. We'll decline that invitation and find that this is not a proper charge that the person before you should take. I invite you, Chairman.
Thank you. Well, I will be brief. And I will start by quoting Justice Odunga in Republic versus Director of Public Prosecutions and another, Spate, Chamanlal Kamani, whereby Justice Odunga said this: the seat of justice is a hallowed place and ought to be preserved for those matters in which the protagonists have a conviction and stand a chance of seeing the light of day. And he adds and says that a trial is neither a showbiz nor a catwalk. Why am I saying this, Your Honor? The DPP under Article 157 has the prerogative to charge. Then again, it is not for sport. It must be exercised reasonably, lawfully, and within the constitutional bounds. The DPP, the office of the DPP, is assumed to be sane and rational. We operate on the gracious presumption that the office of the DPP is sane. But the prerogative to charge, Your Honor, isn't a license to experiment. What, Your Honor, we are telling you is that you don't need to taste the meal to know that something is off. Even the smell of it can tell you that there is something that is off. Finally, Your Honor, two issues. We are not asking the court to test the evidence. What we are inviting the court to do is to test the lawfulness and the sufficiency of the charges. Simple. A criminal trial is only justified where there is a properly framed charge that discloses an offensive law. So we are not saying that we should call witnesses right now. All we are saying is that the DPP has that burden of telling us that these charges are lawful and within the bounds of the Constitution. Secondly, Your Honor, a trial is not a fishing expedition. The charge must disclose a known offense with clear particulars and connect the accused's conduct to that offense from the get-go. If it fails these basic tests, then the charge collapses on its own weight. An accused person must be informed of the charges with sufficient detail. So, what we are saying is that the accused person ought to have known how her words amounted to offensive conduct under Section 94, which is not the case. If the DPP can't say that, then the court is right to stop. In short and in conclusion, we are not challenging the evidence. What we are challenging is the charge's existence as a valid document. If they insist on going to trial without a valid charge, then that's like building a house without foundation. Circumstances submit that charge is effective and the accused person should be admitted to a personal cognizance. Yes. And they have considered to that. To have been released.
I just wanted to mention an authority.
Yes. So just share with us so that we can also assist the court.
Could I give the citation? Yes, Your Honor, the decision I'm talking about is the Supreme Court decision, the bench comprising of Baraga CJ, Ibrahim Ojuang Panjala and Joki, and the case is Hussein with a double S, Hussein Halid with a KH, and 16 others versus the Attorney General and 2 others. The citation is petition number 21 of 2017. And without making the arguments, it is in respect of this court's powers to enforce fundamental rights. So I'll refer the court to paragraph 118 and paragraph 120. Your Honor, if you allow me to just read. Paragraph 118, while that was the law then, the Magistrates Court Act number 26 of 2015 has since been enacted to give effect to Articles 23(2) and 169(1)(a) and 2 of the Constitution, to confer jurisdiction, functions, and powers on the Magistrates Courts, to provide for the procedure of the Magistrates Courts and for connected purposes. Section 8 of the said Act vests jurisdiction in the Magistrates Court to hear and determine applications for enforcement of constitutional rights, but limited only to claims on freedom from torture and cruel, inhuman, or degrading treatment or punishment, and freedom from slavery or servitude, as guaranteed in Article 25A and B of the Constitution. The jurisdiction of the Magistrates Court does not also extend to determination of claims for compensation for loss or damage suffered in consequence of a violation, infringement, denial, or a right or fundamental freedom in the Bill of Rights. 120. We therefore find and hold that there is now legislation that provides on how magistrates courts may determine allegations of infringement of fundamental rights. Though limited, the same is constitutional as an aggrieved person, while he might not on all allegations approach the magistrates court, still has recourse to the High Court, which is the court constitutionally empowered to address allegations or violations of the Bill of Rights. I thank you.
So I must say that that authority you said is open cited. Yeah, it's open in our corridors. Yeah. So thank you for that authority.
Yeah, but just to distinguish it, on one point, and I agree we are bound by the decision of the Supreme Court, but will you not, in a very few minutes to come, enforce Article 49?
That one actually, I was about to say that. You thought, you had the thought in my mind.
We must, I will seated where you are seated very soon.
I wish you that. Alright. So I want to appreciate the council for such erudite submission and the decorum, the propriety. I want to thank you most sincerely. You've made extensive arguments and you cited authorities. We've not had a chance to look at those authorities in the case laws. And also we've cited so many provisions of the Constitution together with the statutory provisions we've cited. So I'll request that I'll defer the ruling. I'll defer the ruling on that application to a later date. But we can now, as Mr. Jeru had indicated, now go to the issue of the accused person being either released, which is not opposed, I'm told. In the meantime, as we wait for the court to make a determination on the application, I believe that's agreeable.
Yes, that's agreeable. The court can determine whatever terms and conditions.
So to that end, I think I'm alive to the provisions of Article 49(2) of the Constitution. So to give effect to that, I'll release the accused person to a personal bond of 50,000. So the accused person will be released for 50,000 pending the determination of the application that we just had. Next week, I'm swamped with so many matters. Actually, I put my willing split 2 days, but unfortunately next week I'm not, so I'll do the other week, the week after next week. So that on the 29th, so I'm supposing if 29th is convenient, we can come back on 29th at 9 a.m. if it's convenient.
Could we do it on first now that the accused will be out on board?
Yes, first is it's amenable to all the parties. So let's first of all do on the day.
propose 11th of August. You know, we have a...
in absence of my new council, I should assume I've taken the role and I request more convenient duties. Thought I think very complex. Yes, I would propose 6 the 11th. There is a date that appears to be more convenient to the council.
We could go back to the 29th if it was continued.
The earlier the better.
Yeah. My colleagues will represent.
So if 29 is okay, usually the sooner the better. 29.
We also agree that we give us the discussion and then we are preparing another hour, another night. Okay. Let's say 11.
So we have it and then my last request, council of science if you define enough say so that I get a different authority than the one you rely on. We know things keep changing.
So they should also ensure they serve us so that we can
so just submit it to us maybe by Monday.
No, we don't have a problem of exchanging and filing with you. What I'm reminding them is that whatever they give to you,
they should also share with you.
They should give us, if there is something that we could take compelling, we could put in a comment. Yes.
So I think just explain your submissions.
I think because of my years of practice, yes. I'm not touching this where council says I have to give the undertaking before the court. When I'm going to tell you we will exchange.
You're right, it's on a light note. I just say that's what you don't say you give us. I think it's been
the links are very compatible. Thank you again. And I wish you all a blessed day.
Yes.